Section 59 Mortgage when to be by assurance, where the principal money secured is 100 rupees or upwards. A mortgage other than a mortgage by deposit of title deeds can be effected only by a registered instrument signed by the mortgager and attested by at least 2 witnesses. Where the principal money secured is less than 100 rupees, a mortgage may be effected either by a registered instrument signed and attested as aforesaid, or, except in the case of a simple mortgage, by delivery of the property. Section 59 of the Transfer of Property Act, 1882, Understanding Mortgages and Assurance. Section 59 deals with the formalities required to create a valid mortgage in India. It essentially dictates when a written document is necessary and under what circumstances a mortgage can be created through the physical delivery of the mortgaged property. Here's a breakdown of the section. 3. And under what circumstances a mortgage can be created through the physical. Part 1. Mortgages above 100 rupees, excluding deposit of title deeds, must be by registered instrument if the loan amount, principal money secured, is 100 rupees or more, and the mortgage is not created by simply depositing the property's title deeds with the lender. Then a formal written document is mandatory, signed by mortgager and witnessed. This document must be signed by the borrower, mortgager, and witnessed by at least 2 people. This ensures clarity and accountability in the agreement. Part 2. Mortgages below 100 rupees. More flexibility for smaller loans, less than 100 rupees. The law allows more flexibility. The mortgage can be created through either registered instrument, same as for larger loans, with a written document signed and witnessed. Delivery of property, except for simple mortgages in some cases. For very small loans, the mortgage can be created simply by handing over possession of the mortgaged property to the lender. However, this doesn't apply to simple mortgages, which are a specific type of mortgage with limited rights for the lender. Key takeaways. Written documents are crucial for larger loans and complex mortgages. Witnessing adds an extra layer of protection for both parties. Smaller loans allow for simpler arrangements, but delivery of property as a mortgage should be used with caution. I hope this explanation clarifies the meaning and implications of Section 59. If you have any further questions about specific mortgage types or the legalities involved, I recommend consulting with a qualified legal professional. 60. Right of mortgager to redeem. At any time after the principal money has become due, the mortgager has a right, on payment or tender, at a proper time and place, of the mortgage money, to require the mortgagee A. to deliver to the mortgager the mortgage deed and all documents relating to the mortgaged property which are in the possession or power of the mortgagee, B. where the mortgagee is in possession of the mortgaged property, to deliver possession thereof to the mortgager, and C. at the cost of the mortgager either to retransfer the mortgaged property to him or to such third person as he may direct, or to execute, and, where the mortgage has been effected by a registered instrument, to have registered an acknowledgement in writing that any right in derogation of his interest transferred to the mortgagee has been extinguished, provided that the right conferred by this section has not been extinguished by act of the parties or by decree of a court. The right conferred by this section is called a right to redeem, and a suit to enforce it is called a suit for redemption. Nothing in this section shall be deemed to render invalid any provision to the effect that, if the time fixed for payment of the principal money has been allowed to pass or no such time has been fixed, the mortgagee shall be entitled to reasonable notice before payment or tender of such money. Redemption of portion of mortgaged property. Nothing in this section shall entitle a person interested in a share only of the mortgaged property to redeem his own share only, on payment of a proportionate part of the amount remaining due on the mortgage, except only where a mortgagee, or if there are more mortgagees than one, all such mortgagees, has or have acquired, in whole or in part, the share of a mortgager. Understanding Section 60 of the Transfer of Property Act, 1882, the right of redemption. This section deals with the fundamental right of a borrower, mortgager, in any mortgage arrangement in India, the right to redeem the mortgaged property. In simpler terms, it allows the borrower to get back the property by paying off the loan completely. Here's a breakdown of the key points. 1. When the right arises. The right to redeem becomes active once the principal amount of the loan has become due. 2. What the mortgager can demand upon redemption. Delivery of documents. The mortgagee, lender, must return all mortgage documents and any other relevant paperwork related to the property. Possession of the property. If applicable, if the mortgagee took possession of the property during the mortgage period, they must relinquish it back to the mortgager upon complete repayment. Retransfer of the property. The mortgagee must either transfer the property back to the mortgager's name or to a third party specified by the mortgager at their cost. Acknowledgement of extinguished rights. If the mortgage involved any additional rights granted to the mortgagee beyond securing the loan, they must acknowledge in writing that these rights are now extinguished upon redemption. 3. Important caveats. This right to redeem can only be extinguished by mutual agreement between the parties or by a court order. The section also clarifies that the mortgagee has the right to reasonable notice before the loan is repaid, especially if a specific repayment deadline wasn't set. While partial redemption, paying off the loan partially and regaining a portion of the property, is generally not allowed, there's an exception if the mortgagee acquires part or all of the mortgager's share in the property. 4. Terminology. The right to redeem is a legal right and can be enforced through a lawsuit called a suit for redemption. 5. Significance. This section protects the mortgager from losing their property permanently even after a default. It ensures they have the opportunity to regain ownership by fulfilling their loan obligations. I hope this explanation provides a clear understanding of Section 60 and the vital role it plays in safeguarding the mortgager's interests in a mortgage transaction. If you have any further questions about specific scenarios or legal implications, seeking advice from a qualified legal professional is always recommended.